Your Honor, this is a case that started as a child support action and then was converted into a custody action. There's a 4-year-old child between the parties at this point. The child has lived the majority of his life up until these proceedings with the mother. Father had limited contact for quite some time, but upon seeking child support, he sought time with his child. Ms. Hewitt represented herself for quite some time in these proceedings, and importantly, there were orders that came down regarding visitation and what that looked like and what that would be. Importantly, the court considered and granted some unsupervised visitation right before Christmas, where the father would have, I believe it was on weekends, from 8 a.m. to 6 p.m. on Saturdays to come see the child at the mother's home. Subsequently, there was a motion filed on January the 21st of this year that was set for hearing on the 29th, a week and a day later, that effectively asked for the court to flip this custodial schedule at that point, citing some issues and some things that the father had concerns regarding. At that time, notice was mailed to my client, but she never physically received that notice. She had been here for every single other hearing that had occurred except for the one where she did not get the notice in time. And with not having the notice and without being here, the court entered the order where the father had the majority of the time with this child and put some onerous terms on the mother, including making her responsible for transportation and some other costs that father knew that she could not afford. Mother currently does not have reliable transportation, and the criminal contempt that we're seeing is related to that in some of the transportation issues that came from this order where mother was not noticed and did not know to participate. At this time, the child has not had much time at all with the mother since that order came down. I believe there were maybe 2 or 3 visits since January that the mother has had because of this transportation issue. The father lives over 2 hours away in Kentucky with this and has taken this child and has in no way facilitated any of that contact. Instead, when mother asks and tries to communicate that she has difficulty transporting and moving this child, he shows up with the police and files this criminal contempt. We will say that this child is at substantial risk of harm, that he has been completely severed from his connection with his mother, that he was raised primarily by his mother up until January of this year when this court changed course, and that he is not having the stability in the placement that he needs, that he's been removed from the home that he's known, the family that he's known, including his sisters and other siblings, that he has not been getting the therapy and the other resources that he was getting through the Dixon County school system in Kentucky, and that we are seriously concerned about where this is going and what is happening to this child with this change in custody. And again, we're just seeking to go back to the status quo and then reassess and see what we need to do moving forward, because we're not denying and saying that he can never have time with this child. We're just saying that this change is too much and too fast for this child that does have some developmental delays and does have some other issues. Ultimately, father set mother up for failure unilaterally at that hearing on January the 29th, and now, in addition to the motion for criminal contempt, they filed a motion for a parenting plan, where if you read their proposed parenting plan, it gives father 365 days with this child and mother 0. They are trying to control the situation and take this child away from the mother. And I am not disputing that it was mailed or not mailed. We don't know, but what we can say is that mother never received this notice. She was not participating in that hearing, and ultimately we're seeking this child to be able to return to mother because there have been no substantive issues that have brought about this change in custody. And for that, I would ask that she be allowed to, or the court reconsider the motion.
All right, Ms. Hendrickson.
Thank you, Judge. First of all, On the face of mother's motion to reconsider, paragraph 1 does state, notice was sent via U.S. mail but did not arrive in time to give actual notice. It does not say here that the mail did not arrive. It just did not arrive in time is what they are alleging. So that is contrary to what now counsel is saying, that she never physically received the notice, is what his actual words today. It's contrary to what he's alleging in his motion to reconsider. But so, Judge, on the motion to reconsider, I researched and researched. I cannot find a motion to reconsider, but I did find a motion for rehearing, and I think that it's traveling under Rule 54.02. And when I looked into that, the burden for a Rule 54.02 motion for a rehearing, based on the case that I cited, Bilbo versus OSHA Place Condo Homeowners Association, 462 Southwest 3rd, 490, and I cited page 494. It states that under that rule, the movant must identify specific facts or newly discovered evidence that's related to the subject of the matter that's being asked to be reheard. In the motion to reconsider, the only thing on the face of the motion that is cited is that father's history. Judge, if you will recall, and I again
I
read.
recall this case.
Okay. So Judge, on January 29, when mother did not show up for the hearing, I did not put forward any evidence as to father's history. The only evidence that I put forward was they were business records from the Dixon Medical Associates, business records from TEIS, or Tennessee Early Intervention, and the cardiology clinic, and some testimony from my client confirming what those records stated and what the mother testified to that conflicted the contents of the business records. And so my first argument against this motion to really rehear, not reconsider, under 54.02 is that on the face of it, it does not comply with the requirement that it should have a colorable claim on its face. It's just not fair for me to, or for my client, for our motion to again be reheard without us knowing what is your new evidence or what is the exact evidence that you're trying to present here for the court to consider. I don't have that. And I have sent discovery also to mother even before she hired a lawyer. And as soon as the lawyer put in his notice of appearance, I sent him my discovery request, which is way beyond the 30 days, and still have never gotten anything from them. On the opposite side, I have provided all the records that I have submitted to the court as part of that hearing. And so that first argument of mine is that under Rule 54.02, this motion to reconsider should be denied. If Your Honor will consider the issue of notice, again, whenever we had the hearing in January of 2029 of this year, I represented to Your Honor that not only did I mail it and I certified it in the certificate of service, I also gave a call to the mother about a week before that, because I was trying to see if we can have an agreed order and forego the hearing. And my exact words to her was that we have a hearing January 29. If you would like, let's have a chat and maybe we can just have an agreement about the visitation. And she had told me that the child and her were trying to get settled because they just got home. And her exact words was, just call me about an hour. And then when I called her, she didn't answer. And then I tried and she just never answered. But I did call her. And you will see in her motion, she did not deny that I called her. She said that the phone call is not adequate notice. because she cannot really deny it, but because I did call her and we did mail it to her. And in my response to, in opposition, I did state that under local rule 5.01 of this judicial district, I only need to serve her 5 days prior to the hearing, and I must provide a certificate of service, and that is a prima facie evidence of proper service. Now, I did cite in my response in opposition that the burden of the movement trying to rebut the certificate of service is found in, it's an unreported case, but I did find a reported case. It's Column versus Adams, 640 Southwest 2nd, 22, which I'm happy to provide a copy. Those cases basically say that if a party is denying service, a bare, plain denial that I did not get it is not sufficient. You must put forward a third party who is disinterested, put forward testimony from that third party to show that you really did not get the notice. And so as far as notice is concerned, I believe that I have complied. We have been mailing it to the same address that she has had all this, throughout this litigation. And so I believe that there was proper notice. And then my last argument would be, if Your Honor, and I believe you already made up your mind when you said that you will consider, reconsider, because you have already appointed, and I'm just making the argument in the event that we have to go to appeals. So I wanted to put it on the record that I did make these arguments. And so, Judge, my last argument is, because you have appointed my client as the primary residential parent, I believe that the burden now is a material change in circumstances, and opposing counsel here is saying that there's substantial risk of harm. And so they must prove that there is a substantial risk of harm.
I think, Ms. Hendrickson, with all due respect to you, this was a temporary order. It was not the permanent order that was put down. And as a result, it would not require a material change of circumstances to change a temporary custody order. It happens all the time. The risk of substantial harm or injury, I think, is the more, if you have a parenting plan that's already, permanent parenting plan already in place, then the statute requires that before a permanent parenting plan in place can be modified on a temporary hearing, there must be a showing of substantial risk of harm or injury to the child. I don't find that either of those apply in this particular case. So.
And I understand that, Judge. And so just to recap, I do believe that on its face, the motion for a rehearing or reconsideration does not meet the requirements of 54.02. Notice was provided pursuant to the local rules. And I believe that mother has not proven or has successfully rebutted our notice. Thank you, Judge.
All right, well, let me first.
I'm sorry, Judge. I do need to set the record straight. We only asked for 365, again, 0 on the mother, which I think we're going to be able to explain that later, but I do want to explain that as it was brought up by counsel. It is because mother has failed to comply with your order to return the child on her last day. And so not only is the father being affected by this because he's having to travel 2.5 hours from Kentucky to pick up the child is also being harmed by this because now he's getting home late. He's got school the following morning. The first time that the mother has violated the court's order, she knew that there was a cardiology appointment the following day, and she refused to return the child. She was able to get the child, but she's not able to return the child on 2 occasions. And so that's why we filed the motion for a second motion for criminal contempt, and we had requested the 365 versus 0 in her visitation to just be in Kentucky or just during the day so that there's not going to be any opportunity for her to not return the child. It's just not in the child's best interest. So this is not trying to be mean or anything like that. If there could be any other arrangement, of course, we're open to that. Thank you, Judge.
All right, I'll deal first with the motion to reconsider this case for some of the history. This case initiated, as was pointed out, by a petition to establish paternity and for support. That complaint to establish was filed in September of 2024. An order went down in November of 2024 to establish paternity and to establish a child support obligation. And from that point, and in fact, I think I'm the one who signed the order of confirmation of that. Then following that, there was a petition to establish visitation that Mr. Fenton had filed, and that came before the court, and we ended up having a hearing, and there was order of visitation that went down. During the hearings, both in that and the parenting time of Christmas of 2024, Ms. Hewitt appeared pro se and testified about the extensive medical conditions that this child suffered from, and how this child had heart issues and other major health issues that she was addressing, and that was her opposition to having overnight visitation with Mr. Fenton. So I then put an order down in November the order went down in November 18th of 2024. There was a specific finding in paragraph 2 that the court does not find any issue as to the father's fitness as a parent. And I believe that it was in the best interest of the minor child to establish the father-child relationship on a gradual basis. And I set forth a visitation schedule to allow that, to gradually introduce the child to the father and then have a 90-day period. Now, I will state also that at the prior hearings, Mr. Fenton testified that the reason that he had not had any contact with the child was because he had been advised by Ms. Hewitt that he was not the father of the child. And for that reason, he took no action and was not aware of his paternity, actual paternity, until that petition to establish paternity and set support was served on him, and he went in for the testing. So I set forth an order to gradually introduce him to the child because there'd been no real contact with him. Ms. Hendrickson, then, being the good lawyer she is, went through discovery and obtained information that led her to file a separate order, a separate motion, and that motion was to establish the fact that Ms. Hewitt had, at the very least, misrepresented the situation with a minor child or had intentionally misled the court. The order that I entered from that hearing on January the 29th, 2024, was the result of a hearing that I found proper notice to have been served upon her. Whether she received it or not, it's her obligation to provide the clerk with the adequate address as a lawyer would be required to do. If she doesn't check her mail when she has pending litigation, that's her problem. The fact of the matter is that proper notice was sent according to the United States Mail in compliance with the rules of civil procedure. In addition to that, Ms. Hendrickson, as an officer of the court, represented that she had spoken with Ms. Hewitt prior to that hearing, and that Ms. Hewitt was made aware of this hearing on that date. So I found, based upon the fact that compliance was made with the rules of civil procedure and the fact that an additional step had been made by Ms. Hendrickson to call and personally speak with Ms. Hewitt, that she had actual notice of this hearing, and therefore it was, in my opinion, proper notice that she should be here if she wanted to contest the issues that were set forth in the motion. As a result of that, we conducted a hearing. And at that hearing, the significant things, and I think it's worth reading into the record, that I found that at the December 18th, 2024 hearing, the mother testified that she had objected to unsupervised visitation due to the minor child's various medical conditions and treatments. However, the proof overwhelmingly at that hearing in January established the fact that the mother was either untruthful or ill-informed, both of which are unacceptable for a primary parent. The mother also testified that she had been managing and fulfilling the minor child's medical care and developmental needs. However, the proof was overwhelming that the mother had failed to meet the child's needs. The court finds that the mother delayed the child's access to services from Tennessee Early Intervention Services for about a year. Furthermore, the child missed 2 consecutive months of developmental therapy by April the 12th, 2022, due to the mother's failure to cooperate with the therapist. The mother also delayed the child's access to physical therapy and failed to have the child evaluated by a speech therapist and ophthalmologist as prescribed in the child's PCP, which is primary care provider Carol Moore. I found that the child requires evaluations and follow-ups for autism, speech, ophthalmology, as well as a well baby checkup and a 2-year follow-up with a cardiologist. I found that the mother had neglected the medical and developmental needs of the minor child, and that the overwhelming evidence demonstrated that the mother was not capable of providing the care the child required. The father had actively sought to arrange for the child to receive necessary medical evaluations and treatments, and he has demonstrated both the willingness and ability to meet the child's needs. He testified that the minor child did not experience any issues in his care during his residential time. And I went on to find that I considered the factors in Tennessee Code Annotated 366106, and I found it was in the best interest of the minor child to designate the father, Matthew Christopher Fenton, as the temporary residential primary parent. And I went forward then to set a residential schedule for the mother. That is the order that I entered. That is the order that, in my opinion, should be upheld. And I am of the, at least, I'm not going to grant the motion to reconsider because, in my opinion, proper notice was given, and there was a factual basis for the rulings that I made at that time. I will then overrule the motion to reconsider and move on to the motions for contempt. Ms. Hendrickson, you may call your first witness. You call it who? The rule has been requested, so anyone who's going to testify as a witness other than the parties must go outside of the courtroom and remain outside of the courtroom until you're called to testify. You are not to discuss the testimony of any other witness with anyone until you yourself have testified. Counsel are under a continuing duty to ensure that the rule is complied with. Do we know if the monitor's off out in the lobby? Double check. All right, Mr. Fenton, come forward, please. Come up, raise your right hand, and be placed under oath.
So Judge, I'm proceeding on the first motion for contempt filed November 19, 2024.
Right.
Mr. Fenton, please state your full name for the record.
Matthew Christopher Fenton.
Okay. And you and the mother, Miss Hewitt, have a child named Ashton, is that correct?
Yes, ma'am.
And he just turned 4 years old last
That's correct.
February?
That's correct.
Okay. And on August 30 of last year, did you have a hearing in front of this court with regards to your motion for a temporary parenting time?
Yes, ma'am.
Okay. And as a result of that, did the court award you some visitation?
Yes, 90 days of supervised Miss Hewitt's house, and then after that, I would get alternating Saturday one weekend, Sunday the next, from 8 in the morning until 6 in the evening, with Ashton, where I could actually take him with me.
Okay. So the first 90 days, you were to have supervised visitation at Miss Hewitt's home. Is that what you stated?
Yes,
And and what time from what time was that?
from 12 to 9.
12 to 9. So you had a hearing August 30 of 2024. So when was your first supposed visitation?
The following day, it would have been August 31st.
August 31st of 2024, is that
Yes,
correct?
yes, ma'am, correct.
Okay. And let me go back. During the hearing of August 30, 2024, Ms. Hewitt, was she present at that hearing?
Yes,
All the way to when the judge made his ruling on your specific visitation.
Yes, that's correct.
Okay, all right. And then so the first day that you visited, August 31, 2024, were you able to see your son that day?
Yes, for a short period of time, about an hour and 20 minutes. And Miss Hewitt had told me to leave, that I would not be coming around there every other weekend. And so I left.
Okay, and so your time was cut short. So if you had from 12 to 9 p.m., so that would be 8 hours, correct?
Yeah, yes. Well, no, 9.
9 hours?
Oh,
I'm not good with math. I think it's 8 hours.
Oh.
And so then so did you say that you only visited about an hour and a half that day?
yes, it was
Okay.
about an hour and 20 minutes or an hour and a half.
Okay.
And I was asked to leave.
Did you perceive any reason why you shouldn't be allowed to complete your 8 hours of visitation?
No, she just got very rude and told me exactly that I needed to leave, that I would not be coming around there every other weekend,
Okay. And so that happened August 31st.
or every weekend, I'm sorry.
Okay. All right. So then let me take you to September the 28th, 2024. Tell me what happened on that day.
See, August
What was
31st,
the date again? I'm sorry.
was that,
September 28th, 2024. Did you send her, did you let her know that you were going to arrive?
yeah, I let
to
her
her
know I was
home?
gonna arrive, and she had messaged me and said that it was her stepmother Connie's birthday, and, that she was be going to her father's for that, and wanted me to reschedule my visitation for the following weekend. And I messaged her back and I let her know that, I'd been waiting all week to see Ashton, and I did not want to miss my visitation. And she brought up child support, and had I sent it yet? And I just let her know that I was be on the way, and she messaged me back and said that she would call her father if I sent the child support, and see if he could come later in the day to get them, and postpone the party till later that evening. And I told her that would be okay. And then she messaged me again about child support, and I didn't respond. I just let her know that I was heading that direction. And right before I got there, she had sent me a message that she had left, or maybe when I got there, I can't really, it's been so long ago. I might have pulled up, I think it was 12:04, I pulled up, and I messaged and said, "I'm here, are you at your house?" And she messaged back and said that she had already went to her father's house, and they would not be back until later that day. I think it was 8 o'clock, and that I couldn't have visitation.
And so on that day, September the 28th, 2024, was that a Saturday?
I believe so.
So that was an appointed day for you to have your visitation, is that right?
Yes, ma'am.
And you did not have the visitation, is
That's
that
correct.
correct? Does that show the text messaging that you just testified to?
Yes.
Okay. And in that text, she did ask about child support, is that right?
Yes, it's,
At the very first page of it?
yeah, I put, she said, "Are you coming? Hello." I said, "Yep, about to leave." She said, "You didn't send child support." And, and I was gonna see if you could come next weekend, because we're supposed to go to Daddy's and Connie's house for her birthday and cook and eat. I said, "I don't want to miss my visitation with Ashton. I've been waiting to see him." And then she replies, "Can you tomorrow then?" And because we've been stuck every Saturday, not going anywhere, and this is important. And then I replied, "I won't be in town." She replied, "OMG." And then she replied again, "Well, when you're sending support, and I'll call Daddy and see if you can come at 4, or if he can come at 4 to get us." And then I put "sounds good" with a thumbs up. And apparently she must have called because it says, she replied, "You didn't answer me about sending child support." And she called me, she said, "Dipshit, LOL." The reason I didn't reply is because I'm driving down the road and I'm not gonna text and drive. It's just against my company policy, and I was most likely in my company truck.
Sure.
And then she put WTH, and she replied again, "Okay, you didn't answer, I won't either." Next
And what
page.
does WTH mean? Do you
What the
know?
hell? And,
It also means what the heck. But we'll
yeah,
look at-
okay, well, just heading to Connie's, we'll see you next weekend. And at 12:02, I sent her a message that said my ETA is 12:04. And she replied and told you we're gone, see you next weekend. Daddy picked us up an hour ago. And then she replied again, "And you still haven't paid child support."
Judge, I want to enter that as an exhibit.
Mark
And
it
it-
as Exhibit 1.
And at this time, I wasn't.
Hold on just a second.
Oh, okay.
Who are the participants in those text messaging?
Me and Amy,
And is there a date on there as well?
yes, there's dates and times as
Can
well.
you just recite the date on there?
Yes, right here is Saturday, September 28th at 12:02. When I sent my message, it says my ETA is 12:04.
All right. I find it has been properly authenticated. We'll mark it as Exhibit 1.
And then she had sent, and you still didn't pay child support. At this time, as soon as I found out March 25th that he was my child, I started paying child support immediately to Miss Hewitt. We talked about it, and I was like, I just want to see my son. It wasn't until, I don't recall the last date, but it was after this when I went to child support court. But I paid child support every week up until that point.
Judge, may I approach?
You may.
This one is Saturday, October 26th. It's
And who are the participants in that text messaging?
me and Miss Hewitt.
Okay. And you did say October 26th is the date on that text messaging?
Yes, it says Saturday, October 26th at 12:14.
Okay. Is that another day where, is it your appointed day to
Yes, that's
exercise your residential time? Okay. And so read that text message for us.
She said, I text her and I said, "I'm at your house for visitation with Ashton. Are you at home?" She said, "No, we're at Daddy's for his birthday this time." And then I replied, "Today is visitation, so are you coming back?" She replied, "Well, you change up Saturday and Sunday whenever you want." And I text you about his birthday and got no response. That was completely false. She had never texted
Just
me.
go ahead and read.
And then I've replied, "You must have texted the wrong number. I've alternated every other week like the judge ordered." And then it said, I replied to this. I said, "We went to court on 8/30/2024. Visitation started the next day, which was Saturday." And she replied, "Connie's cooking and got him a big cake."
Is that the end of it?
Well, no, it keeps going. I just got to flip a page. It didn't show it all. But she had replied, "Connie's cooking and got him a big cake for Paw and giving gifts." And she said, "I'm sorry, but I text you and you weren't at Daddy's for his birthday." That text you that we were at Daddy's for birthday. And then I said, I replied, "That's no excuse. It's contempt of court." She replied, "No, it's not. We had a prior engagement and I text you." And then she replied again, "We have had lives over 3 years without you and still do. Stuff comes up. That's life." And then let me flip it because I'm probably gonna run out. And then I replied, I'll file contempt of court on Monday and see what the judge thinks about it. And she said, okay, and then she sent me a thumbs up.
And so that text message, basically she's saying that she told you beforehand, is that true?
Yes.
She did tell you that there was going to be a birthday party?
No, she did not tell me.
Okay.
I had never received any message from Ms. Hewitt about this party.
Okay, and so there was no alternative arrangement for you if she did in fact had a birthday party to go to, who was her father, it sounded like, she did not make any alternative arrangement for you to visit with Ashton, is that correct?
That's correct.
Okay. Judge, I would like to enter that as the
We'll mark it as
second.
Exhibit 2.
Okay, so now, let's go to November 3, 2024. And is that another day for you to visit with Ashton?
Yes, ma'am.
Okay. And do you recall what happened that day? In fact, Judge, I'll just
There's so many
play
of them
a
that-
video
yeah.
recording of that.
Oh, yeah, okay, I remember now.
Identify it for us first,
Okay.
We're proceeding on a motion. Were there a discovery motion? We're proceeding on motion rather than a final hearing. Was there a discovery motion filed?
No, Judge.
Then you're not entitled to necessarily have that provided to you unless you filed a discovery motion. So overrule the objection.
There was also no discovery request.
But what do we do? What is this?
And so, Judge, I will play
Is it an audio recording?
a video recording.
Video?
So, do you recognize that?
Yes, ma'am.
And where is that taken?
That is at Amy's house, right?
And
right from-
who was taking that?
I was, because I pulled up and I got
I'm just
it.
asking
Oh.
who took that?
Oh, I took the
Okay,
video.
don't explain. And then so, what time of the day did you take that? Was it at the beginning of your visitation?
Yeah.
At the
right-
beginning of your
Right at 12
visitation.
o'clock, as soon as I pulled up, yes.
Okay, right at 12 o'clock.
Sure, who y'all say that runs her mouth about my goddamn daughter and shit? No. Give me my baby now.
I'm here for my visitation, Amy.
Yeah, not here. Grab your brother. Grab your brother.
He's all right.
No, he's not. Give me my son.
All right. So I need to just leave then? Is that what you're telling
If you
me?
don't want it to have visitation like you're
I'm
supposed to,
visitation in your house, right in front of it.
that's not my fucking house.
This is your house right here.
That's not your truck.
My truck is
The
in front of your
parking lot
house.
is not my house.
All right, we'll take that.
Explain what was happening in that situation there.
I pulled up, I knocked on the door for visitation at 12 o'clock. Miss Hewitt was in the back room. When you walk in her house, you go to the living room and then there's a hallway, and she was in the very back room in her bedroom. I'm assuming because she had walked out that way. But her daughter had answered the door, Sophie, Ashton's sister, and it was a nice day, we always went outside to play in the yard, or I would take him to the park that's just walking distance down the road. I had been teaching him to climb those stairs because he has physical developmental delays, is what they called it at that time, but he was just kind of learning to walk at 3 years old. His feet turned in really bad. He didn't have a lot of muscle strength, so every time I would teach him to climb those stairs, there's 10 all the way to the top. We'd count as we go up, and then he really enjoyed getting in my truck, and he would play with the buttons, and he liked the horn, and so that was a normal routine when I got him. He'd be waiting at the door, grabbing his shoes, ready for me to put him on and take him outside. And Miss Hewitt had just come out of the back room, and by the time I made it to the top of the steps, made it to the truck door and opened it, she came out irate, and she had said a few things before, and I just grabbed my phone and started recording at that time.
Is it true that you exercise your visitation in your truck?
I mean, it was never a problem for him to go, but no, I did not exercise the visitation in my truck. Typically, it was in her house, especially if it was a rainy day or if it was sunshine, we would go outside to play. There's not a whole lot of area to play there, but about 500 feet down the road, there is a little park area. And most of the time, it would be me and Sophie would take him down to the park.
Okay.
Or Asia might have been there at that time as well, my fiance. And
Who was she directing to grab her child?
that was Sophia that was up there, ran past. I was holding Ashton in my arms.
And then who grabbed or who took Ashton from your arms?
Miss Hewitt came up
Okay.
and took him out of my arms.
Okay. And so after that encounter, were you able to have visitation that day?
No.
So you just left?
Yes, ma'am.
Okay. So that was November the 3rd of 2024. And we're going to be now discussing the last count, which is November 9, 2024. Were you with someone else when you visited on November 9, 2024?
Yes, my mother, she's here today. She's
Okay.
outside. But she rode down with me. My fiance, Asia, had rode with me. And we went down, knocked on the door. Miss Hewitt would not, I think there might have been some text messages. She was just telling me to leave and telling me Ashton was sick. And I was like, well, I'd like to just give him his chicken and dumplings. I'd stopped at Cracker Barrel and picked him up some chicken and dumplings. I said, it might make him feel better. And so I just sat there waiting. Well, 35 minutes or so passes and the law shows up. Miss Hewitt had called them. And I stepped out and asked the officer, I was like, how'd y'all even know? And she said, well, we got a phone call. I didn't know if Miss Hewitt had called or the neighbor had called or what. And I explained to the officer, it was two female officers, I explained to them, I said, I'm here for my visitation. I provided them with the court documentation. And I said, I just want to see my son and it's my parenting time. And she said, yes. She said, it doesn't matter if he's sick, it's your time. She's got it. She said, I'm gonna go down and talk to her and see if I can get you some visitation time. I said,
I
okay.
would like for you to look at that text message that was handed to you.
Yeah.
Who are the people in that text message?
Amy Hewitt and me.
And is there a date on that?
Yes, November 9th. I think that might be out of order here. Yeah, I think I'm separate.
November 9?
No, yeah, November 9th, and then it starts at 11:56 a.m.
Okay. And you just testified that Miss Hewitt had texted you that Ashton and Sophie were sick. Is that what you testified to?
Yes.
And does that is it confirmed in that text message that you're looking at right now?
Yes, she sent me a message at 9:51 a.m. that morning before visitation, said Ashton is sick, and I text back and I said, what's wrong with him? She replied again, she said, it's not, then he coughs and gags on it, he throws up and has fever. His teacher said Thursday that there was a bug going around and he was ill, snot yesterday, but fever, and now more kicking in, 3 this time. And then I replied at 11:56, I said, I'm at your house for visitation with Ashton. Are you home?
That's okay, Mr. Fenton. So
Okay.
it does confirm that she had represented to you that Ashton and Sophie were sick that day. Is that correct?
Yes.
And you testified that the law showed up, and then what happened? Were you able to have some visitation with Ashton?
Yes, they asked me just to wait in the truck there, but I could see Miss Hewitt's door. She opened the door when they knocked, and Ashton's standing there just jumping up and down. He appeared
Did
to
he
be
appear
fine.
sick to you?
No.
Okay. And then, so for how long did you have your visit?
Well, I think it was about 12:45 is when the law finished speaking with her and called me down to start visitation with Ashton. At 2 p.m., at first, Sophie had come out and told us that her mom told us that they had an eye doctor's appointment. Both of them did, and then Miss Hewitt, told me the same thing. Me and my mother. My mother came in with me as well, and she said the appointment was at 2:30. This was on a Saturday, I believe. Yeah, Saturday.
Okay.
And so I hung around as long as I could because where she lives in Dixon, and the eye doctor, she said, was just directly up the road. But she said that I needed to leave so she could get them to their appointments. And
So so from that time, how many hours have you been with Ashton
well,
so
from
far?
12:45 to an hour and 15 minutes before
Hour
she
and
told me I
15,
needed to.
okay.
Yeah,
And then
but-
did you in fact leave after she told you that there was an ophthalmology appointment?
Yeah, I hung around until about 2:25, and then I carried Ashton out to her car, put him in his car seat, and Sophie got in the front seat, and Sheila got in the driver's seat. I got in my truck, and both of our vehicles were facing the same way. I took off and started driving off slowly, and she turned her vehicle around there in the road, because you kind of park on the side of the street. But it's a loop. You can go up and go out and then come down on a paralleling road, or you can go straight south, or, well, I guess it would be west, down, and then there's another road that parallels going west, and then it goes out to the main road. So I went up and around and down, and when I got to the end of the parallel road, I did not see her car, so I turned down. I went to the Huck's gas station that was just right there on the corner where I would be able to see. And I waited for 10 minutes or 5 minutes, and I circled back around and went back past her house, and our car was still back there.
Okay.
So I
And
went
so
ahead.
that was about 10, 15 minutes and her car was still back there?
Yeah.
But
And
did she appear like she was leaving
Yes.
the property?
yes.
But in your observation, did she really leave?
She didn't leave far enough that she made it to the end of the street, no, because I would have seen her car come out the end of the road. I was in front
And
of
you
her.
testify that your mother was with you at this time?
Yes, that's
Did she
correct.
also witness that?
Yes.
Okay. And so then, are you saying that your visitation on that day was cut short? It's basically hour and 30 minutes?
Yes.
Instead of the 8 hours?
And then when I went out and I was heading back towards the interstate, she had messaged me. I don't know if she'd seen me drive by the house or what, but she did message me, and she said, "Oh, we're back at the house. Ashton threw up."
Okay.
But he did not appear sick to me in the hour and, 45 minutes that I was with him, or 40 minutes.
Judge, that's my proof on my first motion for contempt.
All right. You wish to cross-examine?
Oh, I would like to enter this as an exhibit. Apologize.
Would be Exhibit 4. Video is going to be Exhibit 3.
I just have a few questions about some of these incidents that you mentioned and some of the things that happened. You mentioned this alleged incident that happened on August 31st where you showed up, you saw your child for a short time, and then Ms. Hewitt told you to leave. Is that right?
Yes.
But you don't have any proof of that beyond your testimony here today, do you?
No, sir.
And you were allowed to see this child, and you did see that child on that day.
For an hour and 20 minutes. That's correct.
And on September the 28th, we see the messages in the back and forth. She had messaged you previously to try to reschedule that, and you just didn't reply to her. Isn't that correct?
No, that's not correct. I did reply.
Okay. But she had discussed rescheduling that date with you, and you just weren't having.
I had to leave out of town the next day, so I could not reschedule for my job.
But that visit, you were later able to make that up and have that time with your son.
No, sir.
Your testimony here today is that you never were able to make up the September 28th visit. She never offered you other time outside of what you were court ordered to let you make up
She,
that time.
yes, she wanted me to come the following weekend, but like you stated earlier, it's 2 to 2.5 hours from my house, so you're talking a 5-hour round trip. I work.
So she offered you an alternative and you said no.
Yeah.
And as a matter of fact, on that September 28th, after that party, you were able to see your son for a little bit that day.
No, that's not correct.
Not correct, okay.
She did not show back. She told me she wasn't coming back until like 8 o'clock at night, and that's not possible. I have to get up for work.
On October 26th, or sorry, before I stop or move on, you don't have any other proof, you don't have any other videos or anything else, any recordings of this time on the 28th, do you? You don't have them here today.
No, I don't have them submitted as evidence. That's correct.
Let's move on to October 26th. Again, there were messages between the two of you, and she attempted to reschedule that, and you didn't text her back.
She never texted me, period. It states that in the messages that I never received any message from Miss Hewitt.
So your testimony is that you never received any message at all regarding trying to reschedule or trying to have just a different date on the
I
calendar?
never received anything from Miss Hewitt on that date trying to reschedule. That's correct.
And it was also, you were also able to make up that visit and have time with the child later after that, weren't you?
No, that's not correct.
Let's move to this visit that occurred on November the 3rd. We saw the video. You were still under supervision at that time with your son, weren't you?
Yes.
Okay. And your testimony was that you took this child out of the home
We
to your truck
yeah, we climbed the stairs up.
without telling the mom.
Miss Hewitt never really engaged. She was always in her bedroom, in her bed, every visit.
So on this November the 3rd visit, you take this child that's supposed to be supervised during this visitation out of her home and you place him in your car, and that's when this altercation occurred.
No, we walked up the steps. I walked to my truck to grab a water or something out. He was not placed in the car. She had walked out as soon as I made it to the truck. Sophie, his sister, was directly beside us.
Is she an adequate person to supervise these visits?
She was the only one that was there for most of the visits. Like I said, Miss Hewitt was always in her bed in the back bedroom.
And after that exchange where she was saying, give me my child back, you voluntarily left, didn't you?
Yeah, she was showing animosity and hostile. That's not good for my child to see that, I don't think. I think it was best to defuse the situation at that point.
She didn't deny you any time. You voluntarily left. Is that a yes or a no?
Yes.
Okay.
But when she asked me if I need to leave, or I asked her if she needed to leave, she told me yes, so it's her home.
How often were you taking this child during this time without supervision?
I was never. She would always let us go to the park. I asked before we ever did it, and then it was fine to do.
It was fine except for when you took this child out of the home.
Turn your microphone on.
And just to respond to that, I think it is an appropriate consideration to make when looking at this issue as a whole, who was and was not supervising this child, who was and was not, when she did and did not know where this child was. I think that is appropriate and very important to this contempt proceeding.
Overrule the objection.
Let's move on to this last time in November the 9th. Miss Hewitt had messaged you that this child was sick.
Correct.
Did you have a reason to not believe her?
Yeah, because he was sick every time. That's pretty much was her reasoning every time he was sick or tired. And
But you didn't mention being sick in any of these other incidents that happened from August until November.
well, we'll go on right after this one, and I'll explain the next 5 visits, and every one of them he's sick in. So
That's a little beyond the scope of what we're doing here today, but you had these concerns about your child being sick, but you were able to see your child.
with the police's assistant, yes.
And you said that you just didn't think that he was.
No.
And then Ms. Hewitt let you know that there was an appointment that was scheduled, and you willingly gave this child back to her.
I didn't willingly give her back to her. She asked me
Did
to
somebody
leave.
force you?
She asked me to leave her house. Yeah, it's her home. She asked me to leave. Yes, sir.
And then you just hung around and kind of monitored what she was doing.
I just drove back by her house. Yeah, I went to the gas station before I left town. I drove back by the house to see if she really left.
So you drove past her house with the purpose of monitoring her.
Yeah, after 4 years of lies, I didn't believe too much.
Okay. And you then testified that you didn't see her vehicle leave. Is that correct?
I did see her get in it. I put Ash in the car seat, and Sophie got in the passenger seat. She fired up, put it in gear, spun it around, and started down the hill. But like I said, I left first, went around, and I was in front of her going down on the parallel road.
But did you ever confirm if there was an appointment or not?
No, she didn't let me know what facility it was at. It was on a Saturday. But I did Google search, and there was a facility open, but so.
But you couldn't even confirm. Did you ask her for that?
No.
One moment, Your Honor. Was there ever a point during any of these visits when there was any show of force or compelling issue that made you leave? Did somebody ever physically force you out of the door?
No.
And when Miss Hewitt asked you to leave her home, you just complied?
Yes, sir.
You didn't say, this is my time. You didn't try to, enforce your time.
Yeah, I mean, I tried to enforce my time. I would tell her that, but she would tell me I need to leave. I mean, so ultimately, it's her house.
You voluntarily left.
Yes. And
No
then-
further questions.
Redirect?
Prior to that video recording of the November the 3rd, were you taking Ashton to your car every now and again?
Yes, and to the park, walking down the sidewalk. But the goal was taking him for walks upstairs and down the sidewalk to help his development and leg strength and walking and, getting him where he needed to be.
And was there ever an objection from Ms. Hewitt?
No,
Before that day?
not until that day.
Okay. And you mentioned that you were able to take him to the park without Ms. Hewitt? At
Yes.
some point, okay. Now, on that November the 9th, when the police showed up, but for the police showing up, do you believe you were gonna be able to have your visitation?
No, I'd sat there for 35 minutes. She had not even come to the door. She would not tell me that she was at home. She just kept messaging, telling me that he was sick and I couldn't see him.
Okay, and that 2:30 eye appointment on that Saturday, did Miss Hewitt ever tell you about that? Hey, there's going to be a 2:30 eye appointment
Not-
prior to that day?
Not until 2 o'clock that day.
So you just found out that day?
Yes.
Okay. And you testified that you did not believe her when she told you that there was an appointment. So you felt the need to see if she was really leaving or not. Is that what your
That's correct.
reasoning behind that?
Yes.
Okay. That's all, Judge.
Recross on these, we're still dealing with the first motion for contempt. We're gonna, after this, I'm gonna let Ms. Hendrickson put on her proof regarding the second motion for contempt, and then we'll allow you to put on any proof regarding those two motions. We're trying it as though it were an indictment with counts 1 and counts 2 and so forth, so that the moving party or the plaintiffs will put on their proof, and then the defendants will have an opportunity to put on their proof. Go ahead.
You mentioned that you had been going to the park with your son during this time. Was that with Miss Hewitt, or did she just let you take your son and go wherever?
She just let me take him and go.
And your testimony is that there was no communication, nothing about this eye appointment that happened on the 9th?
No, she didn't not tell me anything about it until 2 o'clock that evening.
And you never followed up to try to see if that appointment happened or not?
No, sir.
I think that's all I have on recross.
All right, Ms. Hendrickson, you want to put on your proof regarding the next motion?
Okay. We are now moving forward with the January 2029 order, okay?
Yes, ma'am.
So on that day, we were before this court, correct?
That's
And you
correct.
were appointed as a temporary primary residential parent.
Yes.
And what was the order with regards to Ms. Hewitt's visitation?
She would receive every other weekend, starting the following weekend after court.
Okay. And what was the transportation order as far as that goes?
Judge Wolf ordered that she was responsible for pickup and drop off and was not allowed to drive with the minor child until she obtained a driver's license.
So then, on February the 7th, is that the first Friday that Ms. Hewitt began her weekend visitation?
That's correct.
Okay. And then, so I will show you a text message. Tell me who the people are in that text messaging.
Miss Hewitt and me.
Okay, and can you give me the date on that?
Yes, it's Friday, February 7th. First message was at 7:31 a.m. from Miss Hewitt.
Okay. Skip to February the 9th, Sunday.
Okay?
That's the day, is that the day when she was supposed to return Ashton to you?
Yes, that's
Okay.
correct.
And then whose message is that one?
The very first one, Sunday, February 9th at 4:58 p.m. is sent from Miss Hewitt.
Okay, please read that for us.
My car can't make it there, and Connie just let me know she couldn't take us because she's got to go stay and check on her dad that lives down the road. In his 90s and a lot of health issues, plus diabetes and recovering from breaking his neck, like literally, or like really did, and he thought he's an old man, so let you know. And
Go ahead.
then Miss Hewitt messaged Ken here. Page. It says, I don't have anyone to get me there today. I apologize. And if you want to meet me tomorrow, just holler.
Okay, and then whose text is that follows that?
This is me at 5:03 p.m. I text, I'm on the way. And then she immediately texts back, well, at 5:05 p.m. There's no sense in coming this late. Let Sophie have this time to play with him before bed. And I'd informed Miss Hewitt and her stepmother Connie that drove her on that Friday when she picked him up that he had a cardiologist appointment the next morning
Okay.
that he was months behind on for his 2-year checkup. And so I responded and said at 5:06, I said, like I said, I'm on the way. And she said, you understand, I'm the only only one that gave child support your name and cooperated, and I wish I never did, because you're going too far with my child. You don't know. Plus you lied, saying you'd never take him from me. And look, I never got notice of any of a damn court date, and you think you're gonna keep my child.
Okay. And so you testified that you had informed Miss Hewitt that there was a cardiology appointment that following Monday.
Yes,
She was aware of that?
yes, and
Okay.
her stepmother,
And her
Amy, the front door was open on the passenger side of the vehicle. Amy was putting him in the car seat and directly behind the passenger side. And Connie, her stepmother, was in the driver's seat, and I was standing on the front passenger door, and explained to them that he had a cardiologist appointment that he had to attend to on Monday morning.
And do you know whose car or whose vehicle was used to pick up Ashton that day?
Yes, it was Connie's. She has a SUV. I think it's a Lincoln Navigator.
Okay, and you have observed that prior? Is that how you know that that's Connie's vehicle?
Yes.
Okay, and so when she said here, my car can't make it there in the first place, she didn't even use that car, is that correct?
No.
To pick up, okay. And what do you know about her car? Do you know anything about the car condition?
Yeah, I mean, it's an older Maximum or Altima. I think it's a Maximum, but I know that I worked on it twice, since I started getting visitation. One time I had to put a new transmission line on for her, and Sophie and Ashton, she allowed me to drive both of them to the auto parts store. And then after I fixed it, she had me run Sophie and Ashton up to pick up Sophie's prescription from CVS. And
So you had work on her car some, but you don't know what the condition was on that day?
No.
If it's
And
running or not?
and
Just
then-
asking that?
yeah,
Okay.
once before I put a hose on it as well, so.
Okay. So then, was there any conversation about who was gonna give her a ride to drop off Ashton?
No, just not at all.
Okay. I would like to enter that as an exhibit, Judge.
Mark it as the next exhibit, which is 5, is that correct?
So then on that day, what did you do upon learning that she was not gonna be able to return Ashton to you that Sunday?
I drove to Dixon immediately. I jumped in the truck, me and Asia, and based off her messages, she didn't want me coming. So I did call the Dixon Police Department and I showed them the court order stating that I have temporary primary custody of Ashton, and he's in my care after 6 o'clock on Sunday. At first, they had called over the phone because we were at the gas station right off the interstate, and talked to her for a little bit. It probably took 15, 20 minutes of them talking to her. And the officer walked over and he said, I think she's okay, and said, you could come pick him up. And he said, but I'm gonna ride along, behind you and follow you just in case. And when I got there, she did have him at the door and had him ready to go.
Okay, please identify the participants in that text messaging.
Miss Hewitt and myself.
And what is the date on that?
Friday, February 21st.
And so on February the 21st, what day is that of the week?
That's Friday.
Is that a Friday? Okay, and then so, did she exercise her residential time?
Yes.
that, okay.
She showed up. Her father had drove her
Okay.
this time.
The father had driven her.
Well, the grandpa, Amy's father,
Okay.
Ashton's grandpa, yes.
And when was she supposed to return per the judge's order?
Sunday at 6 p.m.
Okay, so please read to me that message right below February 23, 4:07 p.m. Whose text is that?
407. That is my text.
Okay,
And where it was a problem the weekend before, Ashton had school the next day and, you know, had to get him, he's on a set schedule. He goes to bed at 8.
Okay.
But he takes a shower and eats before that.
Okay.
So I text and I asked, what's your ETA? No response. So at 4:30, I text again. I said, dinner's in the oven. Ashton has school tomorrow. What is your arrival time? Miss Hewitt texted at 4:45, leaving now. At 5:12 p.m., she texted, running late. And then I texted at 5:13 and I said, okay. Then she had sent me a picture of Uber showing cost, I guess.
Okay.
And then she texted me again and she said, hey, we left with Daddy, and on the way, then he got off an exit after 49 minutes and said Brandon called, which is Miss Hewitt's brother, older brother. He had to go, but I don't know, or IDK, why, and didn't realize that he was going to bring us back home to go get Brandon. So I'm letting you know, I just checked Uber and it's about 158. And then I responded, I said, so what's your ETA now? Ashton needs to be in bed by 8. He has school tomorrow. She replied and said, I called Connie. My car will not make it that far. That's the issue for me and why I have to deal with this BS now. He needs to be home. There's a message over the top of that. Let me scroll to the next page.
Okay, with me, I hate.
He
Just
needs to
start
be
there.
home with me. He belongs with me, and I hate this. All over court date I never knew about. And then she texted and she said, he's got school here too. Has been, you pulled this shit. And then I text at 5:30 and I said, I'm on my way. And then she texts back, let's go to time here on this page. And she texts back and said, you're evil and I wish I'd never given your info to the child support and never had to deal with this cruel shit. He's lost weight, he's dehydrated, and because you know nothing of what he needs, like, or how to care for an autistic child.
Okay, that's okay. I'd like to offer that as an exhibit. And so on that day after that text messaging, were you able to pick up Ashton?
Yes, I drove straight down. I think I arrived around 7:30, and she did have him at the door ready. And I texted her when I got close there, and she did have him ready to go. And I got him back home. Well, when I put him in the truck, his eyes were running, his nose was running really bad, and he had a cough. And ended up getting him home at 9:30 and at night. And so he was probably closer to 10 by the time he took a bath and got in bed. Took him to school the next morning, and by 8:30, his teacher had called and said, I don't think Ashton's feeling good. Can you come get him? So I went and picked him up. His doctor was out that day that was there in Kentucky across the street, but they did schedule me an appointment for the following day.
Okay.
And I
And
took
so
him.
he came home sick, is that what you're saying?
Yes, ma'am.
And so he had to be pulled out of school the following day.
Yes.
That's all I have for this one, Judge.
All right. Cross-examine.
Going back to this January 29th order, included therein, it specifically delineated and denoted that the mother was supposed to be responsible for all the transportation, correct?
That's correct.
And included in that was that she was not allowed to drive if she had any issues with her driver's license, correct?
Yes.
And you've known that there have been some issues with that driver's license.
Yes.
And you asked for the court to order that despite knowing that.
No, that's incorrect. Judge Wolf made that order and he said, "I've done it to you, son. I guess I can do it to her," was his exact words.
But it's been expressed that transportation has been a continuing issue in this case, and going back to those first messages, that was not a willful act from Ms. Hewitt. That was just these circumstances that she could not drive under that order, correct?
She can't drive because of her own, that has nothing to do with me. I have a valid driver's license. I don't have anything on it. You have to uphold the law to keep it.
But you've seen that she's had to have help transporting this child.
No, I think she typically just drives. She has quite a few driving on suspendeds.
But your prior testimony indicated that when you'd seen her, it was in a vehicle that was not hers with somebody else driving.
Yes,
How many times did she actually get to visit with this child since you've had him?
twice.
Twice. And it's both of these times that we're
Yes,
talking about where there have been continuing issues with transportation.
yes,
And when you showed up, she willingly turned this child over to you.
the second time, yes.
So your testimony here today is that she did not turn this child over to you on that first time.
Not without the police speaking with her, and she argued with them for 20 minutes or so about the court order. So if you call that willfully after 20 minutes of speaking with the officers and them showing up to your house, then
But you got your son that day.
yes.
You mentioned that it was so important for him to be back with you because he had a cardiology appointment, correct?
Yes, that he was months and months late on going.
But you don't have any proof of that appointment here today, do you?
Yes,
But you haven't presented that yet, have you?
no.
Okay. And then moving forward to this February 23rd, we continue to see these issues with transportation, and Ms. Hewitt gave you notice that she was going to be a little delayed.
Yes,
And then there was some discussion about getting this done, and then you took it upon yourself to drive down and get him.
correct. He had to be at school the next morning. It was awful late in the evening. That's a far drive.
And all of this is with the continuing issues with the transportation that we've continued to see since this order came down.
Yeah, but I'd assume if you can make it and you find transportation to get there to pick him up, that would be your same transportation to get him back home following the court order.
Just one moment.
You have redirect.
Did you ask Judge Wolf to order that Ms. Hewitt pick up and drop off the child?
No, ma'am.
Has Ms. Hewitt ever filed a motion or request for relief with regards to the driving situation order?
No, ma'am.
That's it, Judge.
All right, step down. We'll take our mid-morning or mid-afternoon recess for 15 minutes. More specifically, the recorder. All right, we're ready. Do you have any other proof on the motion for contempt?
No, Judge, that's my
And
proof.
are you ready on, do you have any proof you wish to offer on the defense?
Yes, Your Honor.
All right, then have her come around. Here, if you'll come around, raise your right hand and be placed under oath.
And before we begin, I do want to have the record reflect that I have advised Ms. Hewitt of the potential hazards of testifying here today.
All right.
Can you please state your name for the record?
Amy Hewitt. Amy Hewitt.
You can pull the base of that towards you so that.
And Ms. Hewitt, you heard some of the prior testimony about some of the interactions and some of the times that there may or may not have been some issues regarding some of the visitation that Mr. Fenton had with your son. Do you remember that?
Yes, and there was 2 times that I,
Let's go
Okay.
through them one by one, and then if there's other things we need to talk about, we can get there. So let's go to this first incident. On August the 31st, Mr. Fenton testified that he saw your child for approximately an hour and 15 minutes or so, and then there was an altercation and you asked him to leave. Is that an accurate reflection of what happened that day?
no, sir. The only reason there was an altercation, and it was after several hours, actually, because I had asked him to quit taking Ashton out into the road. It was teaching him to go in the road, and that's why I was saying visitation isn't in your truck, it's in my house.
I think we're getting a little ahead of ourselves. That was in November. I'm asking about the first visitation that he got in August. Do you remember that? The first time you got to see your son?
The first time he got to see him, yeah, I let him even before then. I mean, there wasn't a time he never was denied seeing him.
How long was that visit on August 31st?
I mean, at least a few hours. He usually let me know when he was gonna go.
And was there an altercation that day not related to being in the road or not being in the road?
No,
Do you remember when Mr. Fenton left?
I mean, he usually stayed till about 6. But I mean, it was never me saying, you need to go. The first visit, I do recall he was overstimulated and it was his nap time, and I just let him know he's sleepy.
Did you offer for him to stay while your child was taking that nap?
Yes,
Is that around the time when he left?
yes.
Let's move forward to the September the 28th. That was the visit with the birthday party. Do you remember that?
Yes.
We saw some text messages and some things presented in evidence. Do you remember those messages?
Yeah, and I got my dad to bring me home and he got to see Ashton.
Were there messages prior to what was introduced into evidence that,
Yeah, asking if he could do it another day because of the birthday. He said no, then he told me he was there. And so I got my dad to bring us back.
do you remember when your dad brought you and your son back?
It was whenever Mr. Fenton said he was at my house.
How long did it take to get from where this party was to your home?
Not even 5 minutes. It was in Burns to Dixon, so
And how long did Mr. Fenton see your son that day?
the usual several hours.
Do you remember when he left that day?
I can't recall of an exact time, but it was by his own, accord. That's okay.
Let's move forward to October the 26th. Do you remember that?
I don't, I mean, all that he came, he got to see him each and every time he came, so
At that time, were you trying to reschedule that visit and give Mr. Fenton some makeup time?
if it's was it October 26th?
Yes.
Yeah, I'd asked him because it was my daddy's birthday.
What alternative time did you offer Mr. Fenton?
I asked him if he wanted to come the next day or if he wanted to do any other day. And he didn't want to, so I came back home from Burns.
And how long did he see the child on October 26th?
The usual 4 or 5 hours.
Do Do you remember when he left that day?
I can't recall what time.
Did he voluntarily leave or did somebody make him?
It's always him when he decides to leave.
Let's talk about the video in November the 3rd. We saw the video that was presented. Can you give us a little more context to what happened before that video started?
Yeah, Ashton because on his visitation, he started just taking Ashton out into the road in the truck and letting him lay on the horn. And then my neighbors were clearly upset about that. And then it was teaching him to go out on the road, and he already knew how to go up steps. I mean, he's been in therapy, but I asked him to either come in the yard or come in the house. I said, visitation isn't in the road. And I explained to him, I said, because now he's going out into the road. And that's what the argument was about, because I was upset. It was teaching him a bad habit of running into the road.
When he picked up your child that day, were you there supervising or did he just take your son?
I was always supervising.
Let's move now to November the 9th. Do you remember that day?
I can't just call it.
Do you remember your son being sick that day?
He had tested for COVID and I sent him the results, and what doctor, everything over text, because he asked.
And how long was Mr. Fenton able to see your son on that day?
The normal, he showed up and I'll, of course, answer the door, and he came in. I just wanted him to be aware he tested positive for COVID. That's why I don't understand, like, I never kept him from seeing him.
Did your son have an ophthalmologist appointment that day?
Yes.
What time was that?
I believe it was between 2 and 3.
Where was that?
It was at, I think, Walmart Vision or Dixon Eye Health. I can't remember. We go to both.
Was there any delay in getting to that appointment? Did you have to
No,
come
I just had a
around?
reminder pop up on my phone, and I was like in front of him, and I told him, I'm like, oh my goodness, I've got this appointment. And he acted fine with it, and he put him in the car seat, Sophia out in the back with Ashton, and we went to it.
Previous testimony indicated that you either didn't drive or they did not see you drive to that location. Did you take an alternate route, or what happened? Why do you think they didn't see you?
Well, they left before me. I wasn't paying attention to if I was being watched or not, but we went to the appointment.
Did Mr. Fenton ever ask about that appointment?
No.
Let's fast forward. We've gone over this January the 29th issue. When did you receive a copy of that?
It was after, it was in February, about February, I don't know if it was 3rd, when I actually got it in the mail. And I didn't know what had taken place, and when he came to pick him up for visitation, I just thought it was normal. And I even said to him, when you get back, remind me and I'll give you his school pictures. And then he was like, I'm not coming back, and then sent me the order. And
Let's talk about that first visit. When were you able to pick up your son?
Oh, the first weekend after it happened, I begged my stepmom to take me. And then I'll let him know that she couldn't take us back because she has, been, I can want burdened, but her grandchildren, she's having to take care of a 4 and 5-year-old. So they were just basically dumped on her. So she was like, I can't. And then just daddy was like, I'm not.
At that time, were you able to drive?
Even if I could, I mean, my car, it needs a throttle body sensor kit replaced.
Was there any alternative you could find that would be able to transport this?
I don't, I mean, besides daddy and Connie, I mean, there was no other way. And they were already griping about driving that far and picking him up. So no, I had no alternative.
Had you communicated this to Mr. Fenton?
Oh, yeah. And I asked him if, you know, if he could bring him, and he just texted me the order.
At that point, did you have the resources or anything else to be able to send your child up there?
If I had, I would. No.
Let's move forward to the next visit as well. That one.
Yeah, the first one, Connie brought me a stepmom, and the second one, daddy picked Sophie and me up. And picked us up, picked Ashton up. He didn't say anything about not bringing us back. In fact, we were in the car on the way there. And then he gets a call from my brother, and just, I mean, we were on the road for, I think, 49 minutes on the way to take Ashton back. And whatever's going on with my brother, daddy just turned around.
Did you stress the importance of turning this child over to your father?
Yeah. And
Was
he
there
just,
a response?
he was just like, well, you'll have to figure it out.
Judge, I'm gonna object to hearsay.
Sustained.
But after you conveyed that this was important, he continued to drive back home.
Yes.
And at that point, I believe in the text message, there was a screenshot from Uber. Did you
Yeah.
have the funds to be able to pay?
No, it was like $158. That's what I was trying to, you know, I mean, if I didn't have to pay rent and everything else, I would have been able to do it, but I didn't have it.
I just want to clarify, your testimony is that you did not have the financial means that day.
No, sir.
Was your child sick that day?
Ashton? He acted very dehydrated when we picked him up both times. And he's a finicky eater, and he's been prescribed through WIC Pediasures also, and I tried to send those things back with Matthew, and he said no. He wouldn't take them or give him his sippy cup or anything.
Regarding these two issues in February regarding the transportation, did you explore other options to try to find somebody that might be able to transport?
Yes.
What did you find? What did you research?
I tried to ask him if he would, you know, even meet me, if I could get, you know, Daddy or Connie to meet him so it wouldn't be so bad. or bring him, and he would just send a picture of the order.
Since this order came down in January, how many times
Only two.
in our the two incidents or the two exchanges, the ones that we've been talking about so far?
Yeah, yes.
Do you want to have more time with you?
Yeah, this is a nightmare. I've always made it to my court dates. If I would have known, I would have never missed it.
And regarding emotions that we're dealing with here, was this a willful choice, or was this a circumstance that was thrust upon you?
The court date?
Like the transportation arrangement? Did you ask for this transportation arrangement? Or was
No,
this just-
I didn't even know about the order or the January 29th when he came to pick him up. I didn't know that would be the last time. I didn't.
Are you asking the court to re-examine that as we move forward and look at?
And also, yeah, he was enrolled in school at Oakmont. He knew that in the peer program, getting all his therapies, he never stopped. He switched from TEIS to the Dixon County Board of Education. Mr. Fenton knew that. I showed him his schoolwork. And I even told him, I've got his
Judge,
pictures.
I'm gonna object to just the non-responsiveness. The question was about her requesting for relief, and now we're talking about other evidence that's not about the
Question of
contempt.
whether she likes this new arrangement or thinks it's in the best interest of the child or not is not relevant to the motion for contempt, unless you want to say that she disobeyed the order because of her disagreement with the order.
No, that is not what we're arguing.
All right, then sustain the objection.
Is there anything else you think the court needs to know about these issues that Mr. Fenton has brought up regarding visitation in the transportation?
I don't know. I've never had to deal with this. I don't know what to do. I can't get to Kentucky.
No further questions.
Ms. Hendrickson, you may cross-examine.
You never provided any text messages for that September the 28th when your lawyer asked you, and you testified that you had offered for him to stay and things of that nature. Do you have any text messages to show that?
To show what?
You testified that you sent him some text messages.
Thank you. I mean, we sent a lot of text messages, so.
But you didn't bring those here today, did you?
I mean, I've got them printed out and on my phone. But I've never kept him from him.
On that October the 26th, and that was incident with regards to,
My dad's birthday.
okay, that was your dad's birthday. Isn't it true that you texted him that it was that you were going to your dad's birthday celebration on that day?
I let him know that it was his birthday and if we could reschedule, but he didn't want to, and so
Judge, this is non-responsive, I would object. I'm just asking,
I came
did
back
you
and he
send
saw
that
him.
message
Hold on,
that
we have an
day?
objection. She's objecting, non-responsive is not an objection to her own question. Non-responsive is saying that her answer is not responsive to the question. Overruled.
So, Ms. Hewitt, let me rephrase.
Restate your
I'm-
question.
Restate the question. All I'm asking is, on October the 26th, which you are saying it was your father's birthday, isn't it true that you sent the text message about the celebration on that day, that same day?
Yeah, I let him know it's my dad's birthday.
Okay, so you did not give him prior notice, not the day before, not the week before. It was on that day when you told him, hey, by the way, you can't visit with Ashton because I'm going to my dad's birthday, correct?
I don't know if it was the day before or not, but bottom line is he saw his child that day.
Okay, and that's your testimony that he did see your,
Yes.
okay. All right. Let's talk about the video recording that we played. Is it your testimony that Mr. Fenton is teaching Ashton to go up the road by himself?
I'm not saying he's intentionally, that was his motive, but that's what was happening. Because he was sitting out in the truck in the road. And so every day he started going, running up the steps and just trying to go straight out in the road after, because most of his visits, he would be basically in his truck.
Okay, when he would do that, would Matthew be there engaging with him? He would run up to the stairs to see his father, is that right?
He was around the truck on the sidewalk and in the road.
So the father will be there when they're outside.
I mean, his girlfriend was in the truck and he would be around walking, doing things. And that's why I was watching out, I was paying attention, cars going by, and that's why I got so irate. I'm like, it needs to be in the house or in the yard, not in the road.
And how long has this been going on before November the 3rd?
I mean, it was going off. I mentioned it probably the last few visits, but
Okay. This COVID situation, you testified that you told him for that November 9 visit, and you may have been confused here. November 9 visit, you testified that you told him Ashton had COVID, but isn't it true that the COVID positive test was November the 21st, correct? Because I have your text message here too.
okay.
You
But,
agree with that?
I mean, I agree, he
Okay.
got COVID then, but he also tested positive for COVID before that.
So the November the 9th, the COVID was not the reason. The reason was that you told Matthew that there was an
He was gagging on
ophthalmology
his-
appointment. Let me finish my question. November the 9th, he had his visit, and then it was cut short because you said there was a 2:30 ophthalmology appointment, correct?
Yeah, and he was
Okay.
fine with that.
Okay. Your lawyer asked you about November the 9th, and your answer was, I told him that Ashton had COVID. So that was not true.
Well, I mixed up the dates. It's in the
Okay.
text messages.
Fair enough. Okay. But there was a COVID positive test. It was just not November the 9th. Can we agree on that? It was November the 21st, correct?
I guess.
Okay. Now, you said that it was Walmart or Vision.
We
Which
go-
was it?
It's either Walmart Vision and we see, what used to be Weiss's Eye, I think it's called Dixon Eye Health now.
Okay. You talked about, your lawyer asked you, are you able to drive? Now, isn't it true that even if you had the most beautiful car today, you're not going to be able to drive, correct?
No,
How is your what is the status of your driver's license today?
I've paid everything. I just have to go to Nashville. And that's been my problem to get, because there's no reinstatement place in Dixon.
It is currently suspended today, correct?
Yes, I've paid everything, done everything. I have to go to Nashville to
And
get
it
it
was,
reinstated.
okay. And when was that suspended? Do you recall?
No,
It was last year?
I don't recall the date.
Isn't it true, August of 2024, you were arrested for driving without a license, correct?
No,
And I can bring up the general sessions record if I need to.
Were you talking about when we were in court
Yes.
and yeah, and that's gonna be, oh, I don't guess I need to speak on it, but I never got pulled over.
Okay. But you were charged with driving without a license, correct?
Yeah, and that's been, I have to go back to court over that, but I never got pulled over. I was
Okay.
in the courtroom and I did not drive that day.
Okay. So tell me, is there a court hearing specifically for that charge or any other charge with regards to your driver's license?
Yes, we go back in June
Okay?
and they're gonna show proof, that I wasn't driving.
Okay. So it's not true when you said earlier that all you need to do is pay the fines, because
I've
in
already paid the
fact,
fines.
okay, let me finish. In fact, you still have a hearing in June for this very same charge. So it's not only that you have to pay the charge, you said you have to go to Nashville and do all these things. You just said that earlier.
Yeah, I just have to go get it reinstated.
But you
but-
have a hearing in June, correct?
Yes, and it's gonna
Okay.
show proof that I wasn't driving or got pulled over.
Okay, all right. So that is all about the driving without a license, correct?
Yes, and I wasn't driving.
I'm not asking you about that. You may want to just wait on that when you have your hearing, okay? We're not gonna litigate that here. Okay, so as we sit here today, your driver's license is suspended, correct?
Yes, I think we've covered
And how
that.
long has it been suspended?
I guess about a year.
Okay. All right. So on the February 7 count that we included in our contempt motion, you were supposed to return Ashton on that day, Sunday, correct? And so before you exercise your residential time that Friday, isn't it true that you did not have an arrangement for the Sunday drop-off?
No, I was told Connie my stepmom was gonna be able to, just like she took us
Okay.
there, she was gonna be able to bring us back. But then she got her grandchildren kind of dumped on her.
Okay. And then the same thing happened on the 21st. Again, you were able to pick up, but then
that was-
something happened again, came up again as you testified, so that you're not able to drop off, correct?
Correct, and I let
Okay.
him know ahead of time what was going on, exactly
Okay.
when it happened.
Well, in that text messaging, which I provided a copy to your attorney, you sent him Matthew, a picture of the Uber cost, correct?
Yeah, I was showing him how much that cost. I was like, I can't.
Did you ask him to help you with the cost?
No.
Okay, so why show him the cost?
To show him how much it is, like I'm trying to get him home, but I can't afford this.
Okay. That's all the
mean-
questions I have, Judge.
Redirect?
Do you think it was safe for your child to be in the road with Mr. Fenton during that November 3rd?
No, I mean, that's, and I was asking him, and then he didn't want to hear it, and that's when it, elevated.
And then on November the 9th, your child, your earlier testimony was that your child was sick. Do you remember exactly what his symptoms were?
I don't know if that was the COVID. I mean, I know he tested positive for COVID twice in November.
Moving forward to this transportation issue and your suspended license, Did you feel like you were stuck between a hard place of either
Definitely.
driving and violating the order or having this issue and having a hard time changing the sign?
Yeah, I never thought I'd even be without him, much less this.
No further questions.
Any other
No
questions?
further questions, Judge.
Ms. Hewitt, I'm interested in this appointment that you say that you had on the November the 9th, I believe it was, when you said that you had an optometrist. Was it an optometrist appointment or an ophthalmologist? Those are two distinctly different appointments.
Oh, it was a optometrist appointment.
Okay, and you understand that if you had an appointment with Walmart Optometry or with Dixon Eye Health, where I happen to go, they're gonna have a record of whether or not your child had an appointment that day. Do you understand that? You're testifying under oath today that your child had an appointment that day.
Yes,
Is that true?
that's true, but we left when he threw up in the lobby.
So when when Ms. Hendrickson obtains the records from either of those places, then it should reflect that your child had an optometrist appointment on the date you said.
Yeah, him and Sophia, my daughter.
Okay. Step down. Hillary, do you have any other witnesses? Do you have any rebuttal proof?
No, Judge.
I'll hear you in argument.
The text messages speak for themselves. It is clear that Ms. Hewitt, on both of these criminal contempt motions, was aware of the orders and the residential times and days. She was aware of all these orders. She knew when my client's residential time was to begin and to end. She knew when she was supposed to drop off the child. In all the text messages, we do not see any prior communication that, hey, I'm gonna have a birthday celebration coming up. Twice that happened, and she would text him on that day. That's just not reasonable, especially when she is aware that Mr. Fenton drives about 2.5 hours. By the time he gets those messages, he's probably on the road. Again, the text messages speak for themselves. I'm not gonna belabor that. The messages some of them are pretty hateful. She doesn't show any compassion that father's missing his time. And so we would ask that you find Ms. Hewitt in contempt for all the counts that we have itemized in our motions. Thank you.
Mr. Hillary?
These are two motions for criminal contempt with an evidentiary burden beyond a reasonable doubt. And we have not simply seen that here today. The proof that's been presented has shown that there have been some issues and some things, but not to the point of criminal liability. Contempt of court is a willful non-following of a court order. And the proof that we've seen here today is that when there were disputes, and Ms. Hewitt testified that she went above and beyond to make sure that Mr. Fenton did have this time. There were issues, I do admit that, but she testified that on all 5 of those visits that were of issue in the first motion, that Mr. Fenton did see this child and saw him for an appropriate amount of time. And there was not substantive evidence that countered that. Additionally, under the January 29th order, Ms. Hewitt was responsible for the transportation with her current driving situation that put her in a very precarious situation. She had attempted to move forward and get other people to help her transport, but as she testified, it was difficulty with other people being unreliable and the fact that she did not have the resources to pay for that Uber at that time that ultimately led to that result in Mr. Fenton picking up the child. It is a lack of willfulness in the second motion in the 2 counts therein that I negate any sort of criminal liability under contempt. Again, this is not a willful choice of Miss Hewitt to try to get away and stop him from seeing this child. It is simply an effect of some of the consequences and the downstream consequences of her not being here on January the 29th. But we've gone over that over and over, and I think at this point, the proof does not show beyond a reasonable doubt that she willfully violated this court's orders.
Hendrickson, you have any response?
Again, I would just point out, especially the second motion for contempt, the responses of Ms. Hewitt, they were pretty hateful. Instead of her saying, okay, you're coming, I'm going to get him ready. Instead, you're evil, you're this, you're that. I wish I hadn't talked to the child support services. She didn't really mean to return the child. She wanted to keep the child. And Mr. Fenton, being a good father that he is, he said, okay, I am going to drive 2.5 hours. I am on my way. And what does he get? More hateful text messaging. That is willful.
Well, the court has considered the testimony regarding the initial motion for contempt in count, well, I'll deal with each one of the counts. In count one, there's a testimony that his parenting time was supposed to begin at 12, and he was supposed to, under that original court order, was to be given, I think it was 12 to noon, or to, I think it was 1 to 9 maybe.
12 to 9 p.m.
12 to 9. And so that's a period of 9 hours that he was supposed to have visitation with the child. That couple of hours or 4 to 5 hours is not the same as 9 hours, but in any event, it appears that that was during an adjustment period when they were beginning to try to set up the visitation and begin the visitation. And most of those instances, this court is of the opinion that those explanations that were given don't rise to the level of willful contempt because of the fact that there was some visitation that may have been cut short, or he may have agreed to not. The cutting short of the supervised visitation on the date when he had the child up on the sidewalk and she came out, her response is indicative of her attitude towards the visitation entirely. And that is also reflected in what I'll deal with in the next set of motion for contempt. But as to the initial motion for contempt, I do not find that the proof rises to the level of willful and deliberate contempt, criminal contempt, and therefore I find her not guilty of those charges. On the second motion for contempt, there's really only 2 instances, and in those instances, she was supposed to be complying with the order of this court regarding the change of visitation and the schedule of conduct. It's interesting that the fact that she was able to obtain transport to pick the child up, but suddenly then transport fell through. Frankly, this court does not find Ms. Hewitt to be a credible witness based upon not only today's testimony, but also my observation of her demeanor in today's testimony, my observation of her at prior hearings in this court, and my belief that there was misrepresentation at the very least to this court at prior hearings regarding the medical condition of this child, which has been later proven by satisfactory to the court's satisfaction by evidence at a prior hearing when I changed the custody of the child. So when I read these text messages, for example, on the count 1, which is the February 7th date, when she picked the child up and then wasn't going to return the child, and he indicated he'd be there to pick him up later this evening. And then she said she'd be there later to pick him, be up there later this evening. He'd be ready at 6. And then on the 9th, when he was supposed to be ready to go home to his dad's, her statement was that her car couldn't make it. Connie just let me know she couldn't take us and so forth. And then she said, I don't have any way to get there. He said, I'll come and get him. I'm on my way. Because he had a cardiologist appointment. Again, that's one of those factors that the court used in determining that this child was better off with the father than with the mother was that the child's medical needs were not being met, and it was not being given the importance that this court found a cardiologist appointment for a child of this age is extremely important. And heaven and earth should have been moved, and Mr. Fenton moved heaven and earth to come and get the child. Her response, as Ms. Hendrickson pointed out, is instructive. Her response was when he said, like I said, I'm on my way. You understand, I'm the one that gave child support your name and cooperated and wish I never did because you're going too far with my child and you don't know. Plus, my child, you don't know. Plus, you lied saying you'd never try to take him. And look, I never got notice of a damn court date, and you think you're keeping my child? Question mark. I find her guilty of willful and deliberate contempt in regard to the denial of return of that child on that occasion, failure to comply with the court's order. On the next date of October the 26th, again, this is a situation where, I'm sorry, that's not right. It was February the 21st. Again, she did not bring the child home as was required under that initial court order. She talks about her lack of ability to do it, her car won't make it, and so forth. And then she said, I called Connie, my car would not make it that far. That's the issue for me, why I have to deal with this BS now. He needs to be home where he belongs with me. I hate this all over court day I never knew about. He's got school here too, has been. You pulled this shit. I'm on my way. And he said, I'm on my way. Her response to that was, you're evil. And I wish I'd never given your info to child support and never have to deal with this cruel shit. He's lost weight, he's dehydrated, all because you know nothing of what he needs, likes, or how to care for autistic child. He has to have a sippy cup of pedicure and toddler pouches of fruit or vegetable yogurt. And anyway, I'm of the opinion that again represents an intentional and willful, deliberate violation of the court order or failure to bring the child back. And for that reason, I find her as well, in that instance, 2 counts of failure to comply with the court order, and found that she is in willful, deliberate contempt. Sentence her in each of those cases to 10 days in the county jail. I will suspend that based on the fact that it is her first occasion to have violated the court's order. But I want to make it clear one thing, and that is that I will not hesitate to lift that suspension and have you serve those 20 days in jail consecutively, which I'm allowed to do under an order for violation of a domestic relations order. I can make that 10 days in each of those counts consecutive to one another. And I will do that if you try to play games with this court's orders, or if you do anything that indicates to me that you are violating a court order. Your attitude towards Mr. Fenton is going to be reflected in your child if you are not careful, and I will not tolerate that. I'm going to change or modify the order that I previously entered, because typically, and this is for Mr. Fenton's benefit as well, typically transportation between parents is shared equally. And I think the safest way to ensure that we're not going to have this kind of gamesmanship is that she will pick the child up at your home at the beginning of her visitation. I will alter the pickup times to 4 p.m. and rather than 6 p.m. because that takes into consideration the 2.5-hour drive home. So she'll pick the child up on those Fridays at 4 p.m. You will pick the child up in Dixon County at 4 p.m. on Sunday. And that will give you an opportunity to get the child home by 6:30 or so before you have to go to school. And they'll also guarantee that you know you're getting your child back, and there's not going to be any of this, oh, well, I can't bring the child back. If she can't get transportation to pick the child up, and she's not there within 15 minutes of the allotted time, then she has waived her visitation for that weekend. In addition to that, Ms. Hendrickson, your client has the right to request a payment of attorney's fees for this motion for contempt, and you will submit your affidavit, and I will consider that affidavit in
Yes,
that matter.
Judge.
I am not, in this point, going to consider your motion to fix a permanent parenting plan because Mr. Hilliard is just new to the case, and I assume there will be discovery and so forth, and that is a final hearing issue, so we'll do that. That concludes this hearing in this case, and that is the order of this court.
Thank you, Judge.
I
I'll
would simply
draft the
point
order.
out that these parties need to try to cooperate a little bit better, and this discussing with the child, or I don't think there is a lot of evidence of the child being, having this discussed with him, but the instance of the video, that the things that were said in the presence of this child, you'd be surprised how young children can pick up on those things. So this order needs to reflect that there will be no derogatory statements, no argument during any of the exchanges that will take place as well.
Judge, would you like for me to draft the order?
Pardon?
Would you like for me to draft the order?
Yes, if you would draft that order, please. And the order regarding the transportation remains the same. Both parties are under an obligation to make sure the child is only transported during the residential time or during exchanges by someone with a license, an affirmative, valid license. All right, thank you.
Thank you, Judge.
This originated as a complaint to establish parentage filed by the District Attorney's Child Support Office, if I understand correctly.
Yes.
And paternity having been established, this is a motion to set visitation. You are Amy Susan Hewitt. Ms. Hewitt, you understand why we're here today?
Yes, and I would like to get a GAL or a PASA advocate and request that before making any determination, the court review his criminal record, request the record of any child protective investigation, and that he's been involved with, and require he take a drug screen.
Well, first and foremost, let me tell you that there's a motion that has been filed to set visitation, and that motion was set for hearing today. You have not yet filed any sort of response to that motion as far as this record reflects. Have you filed anything in writing?
I don't have an attorney.
Yes, ma'am, I understand that. The child support DA is not going to represent you in this matter because that's not their job. They only handle the child support action. But you have the right to hire an attorney of your own choosing if you choose to do so. The question is whether or not you are planning to do that.
I'm told to ask for.
A guardian ad litem.
Oh, sorry.
Guardian ad litems are not automatically awarded because of the simple fact that if I appoint a guardian ad litem, there has to be, number one, a valid basis for the appointment of a guardian ad litem. Number two, it has to do with who is going to pay for the guardian ad litem's fees. They don't do it for free. Usually there's an attorney that's appointed, and that attorney expects to be paid according to that. And in a civil case, most of the time, the guardian ad litem is paid by either one or both of the parties. So it would be an expense to you and to Mr. Fenton. So paternity was just established in May of this year. According to the file, it says that on May 20th of 2024, the court held that the father was the biological father of the minor child. Well, I cannot, simply because you asked me to appoint a guardian ad litem. Now, as far as the CASA, you have every right if that's what you choose to do, but that is not something that the court normally orders as well. You have opposition to Mr. Fenton having visitation with a minor child?
I'll let him come around supervise a couple times over. He lives out of state.
Well, here's what we're going to do. We're going to conduct a hearing of sorts, and I'm going to hear from him about what he's asking me to do, and because he set this motion, and then I'll hear from you about what your reasons are. What you're stating is really testimony, and I need that to be under oath. So we'll have this hearing, and then when I've had the hearing, I'll make a decision on what, if any, visitation or whether to appoint a guardian ad litem at that point, okay? Just have a seat at that table, please. All right, Mr. Murphy, you wish to put on proof?
Yes, Your Honor. We would call our client, Matthew Fenton. to
Mr.
stand.
Fenton, step around, please, and have a seat in the witness stand. So.
Could you please state and spell your full name for the record?
Matthew Christopher Fenton, Matthew
And Mr. Fenton, are you the co-parent, are you a co-parent of Amy Susan Hewitt?
Yes, sir.
Both of you have a child together?
Yes, sir.
How old is the child?
He turned 3 February 28th.
And you're here today because you would like to begin visitation with the child, is that correct?
Yes, sir.
Okay. Have you
Well,
made any,
you're gonna have to speak into that microphone a little bit more.
Yes, sir.
have you made any efforts thus far to get visitation?
Yes. She allowed me to come on 3 visits. My
Who is
mom,
she?
Miss Hewitt allowed me to come 3 different times after March 25th when I was, I'd taken a DNA test. And I went to her house after 12 noon, and I stayed until 7 2 times, and then the third time I stayed until 9 p.m. My mom, that's just turned 82 years old, she went twice. That's the only 2 times she's ever seen him. And we just would like rights. I was never told the truth. I was told that it was another man's child, that she had DNA tested the father. I came in when he was born, or when his expected date was February 24th, 2021. I was working in Virginia, and I drove in from out of state, 8 hours away, and Miss Hewitt told me that it was not my child, that she had DNA tested the father, that it had nothing to do with me. I never heard anything back, and I don't know. I believed her. I've never had a child before. This is my only child. And I'd just like to, be involved in his life and get to visit him.
Has Miss Hewitt refused you visitation at any point?
Yes, sir.
Tell us about that.
I went 3 times. Well, we had the court hearing, and it said on the documents that you have there, Mr. Wolf signed off that I should receive reasonable visitation. And I highlighted it and sent a copy to Miss Hewitt and asked her for visitation. I even really wanted to get him for Father's Day, because I'd already missed a few. And I drove down and went to the district attorney's office that day and spoke with the child support lady as well. And, she told me to contact my attorney, and then I came on to the courthouse. But yeah, she will not allow me to see him, and told me not to come back to her house. And that pretty much happened when I filed for visitation rights.
Did you advise her that that was part of the court order?
Yes, sir.
Looks like alternate residential parent, non-custodial parents will have reasonable visitation privileges. Did you tell her about that?
Yes, sir.
What was her response?
She doesn't care.
And you did give her a copy of that?
Yes, sir.
Okay. You just heard her make some claims just now when she appeared up here at the podium about criminal charges and all sorts of other things. Do you have any kind of response to that?
Yeah, I don't have a criminal record. I've worked on federal projects for the last 23 years since I was 18. I'm currently doing a Send Elements battery recycling facility, which is government-backed and is a federal project. I take random drug tests and more than happy to take one right now today in court. And I don't even have a bad driving record. Nothing's on that as well. So
Where do you live at?
I live in Scottsville, Kentucky for the last 16 years. It'll be 17 years in April of next year.
Okay. So just from so we have just understand how this would work. How would you propose, visitation work if you being out of Kentucky and her being here in Tennessee?
I'm more than happy to make the drive to come pick my son up and drop him back off. Just whatever it takes to see my son.
You just want to start seeing your son again?
Yes, sir.
Okay. Let me ask you this. Have you taken a parenting class recently?
Yes, sir. I have a completion, but it's on my phone. I don't have it printed off. But
You don't have a physical copy, but you did complete it?
Yes, sir. And
This morning?
I emailed it to you as well. So we can get that,
So you'd be happy to late file it if we have to?
Yes, sir.
Okay. All right. Those were all my questions. Thank you very much, Mr. Fenton.
Hewitt, you are representing yourself at this hearing. You have the right to ask questions of this witness. I'm going to give you a chance to testify if you want to testify, but do you have questions that you want to ask of this witness? You're not required to ask questions. I'm just giving you the opportunity. If you want to ask questions, they must be in question form, and it must relate to some issue that's before the court. Do you want to ask him any questions about what he's testified to?
I gave you time with Ashton supervised at my house, right?
I took him every time that I was there, and your daughter.
And supervised
eat.
and with your mom.
No, I mean, the first time wasn't, my mom wasn't with me.
You just testified your mom came with you. The two.
Twice.
Yeah.
The one
And she-
time, the first time I came alone, and I took him to the auto parts store to get parts to fix your car because it was broken down. And I came back on my first visit and fixed it so you had transportation. And then also gave her money to get insurance and to get her tags for her vehicle so they would have a reliable vehicle and transportation.
I never denied you that seeing him at my house supervised, right?
Yeah,
I denied you.
the messages I have say not to
I've
come
got
back.
all of them printed out along from your ex-wife too,
Okay, I mean, I don't,
where
you shouldn't have, I don't see,
the reason is he's autistic, nonverbal. You've known about him since day one.
Number one, you're testifying now. I'm going to give you a chance to
Sorry.
testify, but you are not required. I mean, you cannot make statements and testify at this point.
Well, CPS has been involved with him in the past and his ex-wife.
And again, you're testifying, and I'm not going
I'm
to allow you
sorry,
to do
okay.
that until you take the stand, okay?
Okay.
All right, thank you. Oh, let me ask you a couple of questions.
yes, sir.
You're asking for visitation at this point, but in the petition that you filed, you asked to be made the primary residential parent for this child. You aware of that?
Sir,
In other words, you want to be the person who has full custody of the child and she has visitation.
yes, sir.
Even though you've not had but 3 visits with this child since he's been born?
Well, I mean, I'd like to make up for lost time and at least have, split visitation with him where, I mean, he's taken to me very well. I mean,
No, she's made statements several times about this child having some special needs. Are you aware of any special needs that your son has?
yeah, he's nonverbal. He doesn't speak, but I'm able to teach him stuff pretty easy.
And he's 3 years old.
Yes,
Okay.
sir.
Anything further, Mr. Murphy? Thank you, sir. Step down. Mr. Murphy, you may call your next witness. All right. Ms. Hewitt, do you want to tell me why you don't want to let him have visitation? Then come up, raise your right hand. Let's place you under oath.
He has a bad history, and I've got proof from his sister, his ex-wife.
Well, number one, let me explain to you that this is a court of law. That means you can't just get up and say you've talked to somebody and they've told you things. You have to have those people come in as witnesses and testify themselves of their own direct knowledge. Otherwise, what they say would be considered to be hearsay. In other words, we could have witnesses come in all day long and say, well, Joe Blow out here told me that the father is a terrible human being and he does this or does that. So it's not sufficient for you to bring in statements of other people who supposedly have knowledge. You would have to have some sort of testimony from them in person so that Mr. Murphy, representing your child's father, would have the opportunity to then cross-examine them to determine whether or not they're being truthful or not truthful. That's the way the system works. So.
Get in their sealed court documents, but his ex told me she would resend them to me.
Again, Mr. Murphy's objecting to you saying what
So I
his
would need
ex-wife.
her,
When I'm talking to you, just be quiet, okay?
sorry.
When Mr. Murphy is objecting to you saying what the ex-wife said, which is the very reason that I've explained to you, that it's considered to be hearsay, a statement by someone made outside of the court that you're bringing in to prove the truth of what's in that statement. That's classic hearsay and it's not admitted. So tell me, other than what someone told you, what knowledge do you have? First of all, what kind of relationship did you and Mr. Fenton have before you became pregnant?
I was best friends with his sister, and we grew up together.
Okay.
I love his mom, love his sister. They had warned me prior, but
How long did you and Mr. Fenton have a relationship?
it was 3 months until he started acting erratic.
When you say, if you saw something that he was doing erratically, tell me what you saw that you think was erratic.
driving crazy, screaming, scaring me and my daughter, cussing, throwing things.
And why were those things happening?
Be honest, I don't know.
Were you and he having an argument?
Not at all.
Was he under the influence of some substance? You have any knowledge of that, or are you just assuming that?
I have knowledge from being around past family members with the same issues and talking to his sister and mother and them informing me, you know.
Again, Mr. Murphy is
sorry.
objecting, so I'm sustaining his objection. I won't allow you to testify about what they said. So you become pregnant, did that end your relationship, or did you stay together after you became pregnant?
Well, I've got my messages in his, but he didn't want us to, he just dropped off the earth because I wouldn't uproot my children and go live in a travel trailer while he worked out of state.
So when did you and he stop having a relationship?
I was 4 months pregnant.
All right. From 4 months pregnant until March of this year, did he ever see or have any contact with this child?
No,
Okay. Did you ever refuse him to have contact
No.
with the again, just wait till I'm finished. Did you ever refuse to let him have contact with your son before that March date that he's referred to?
no, sir.
Did he ever contact you before he was served with a petition to establish paternity and to set child support? Did he ever contact you and ask for visitation?
No, sir.
All right, so the first time he asked for visitation was after you and he had been to court over the child support?
Yeah, it's about,
And then you allowed him to have supervised visitation, coming to your house, being with your child, correct?
yes, and his
All
mother.
right. And his mother came along too?
Yes.
Is there any reason why you would not allow him to have that type of visitation right now?
I never said that I told him he could come to my house supervised.
Tell me about your son. What issues does your son have?
He's got a rare heart condition, Epstein's anomaly, pulmonary hypertension. And then he's nonverbal autistic. He gets therapy through the week and PK3
Where does he get therapy?
at pre-K with special services. He's started at TEIS, Tennessee Early Intervention,
Okay.
from birth, and then we moved over to with the Board of Education when he turned 3, and he goes to school during the week, and he gets OT, PT, speech, ABA,
And where does he go to school?
Oakmont.
Oakmont. Now, what I'm understanding you to say is that you have concerns on what people have told you about Mr. Fenton and his past, but that you would be willing to let him have visitation at your home?
I would be willing to let him, if I was there, just not
Well, that's what I'm-
him. Yes, sir.
But you don't want him taking the child away at this point?
No, sir.
All right. Anything else you want to tell me about, other than what somebody may have told you? Is there anything else you want to tell me about your son? or
It's
Mr.
my
Fenton?
world.
You understand that when he was held to be the father by the child support magistrate, then that means he has certain rights under the law, that he has a right as a father to see this child, his son. The only question, you don't get to have it both ways. You don't get to have, for example, the child support paid but no visitation, absent a finding that he poses an immediate and serious harm, threat of harm to your son. In other words, if you establish paternity, those rights go with the child support obligation. He has a right to see the child. So the question is, do you understand he has a right as a father to visit with his son?
Yes, and I never denied him seeing him.
Okay.
And I've raised a 22-year-old with autism who's in college, successful, works at Walgreens as a pharmacy tech. I've got a 12-year-old with autism also. Like, I've done this a long time, and I've known him a long time, and he wouldn't be safe.
Mr. Murphy, you have any questions?
Let me ask you some questions. First off, I think you made it pretty clear. You said you're not opposed to him having visitation with the child. Is that correct?
I never was, as long as it was supervised, I was there.
Okay, what exactly are your concerns as far as him being able to have the child at his house?
Number one, he's never raised a child or been in his life for 3 years. He doesn't know him. I mean, just because he puts his hands up to him, he does it to any man because he's not around men.
So how much time would you say would be needed to get to know the child before you'd be comfortable at that stage?
With him, what stage?
With him actually having a child at his house?
I don't know.
You don't know.
I mean, he's autistic and nonverbal, and I mean, he's a complete stranger.
Have you given Mr. Fenton the opportunity to assist with the child's autistic and nonverbal needs?
I was more than willing. The only reason I objected to anything was when he told me to have him ready Friday night, and then he would drop him back off on Monday. That's when I cut it off.
What do you mean that's when you cut it off?
That's when I cut off. I was like, you're not taking my child out of state that can't even tell me when something's wrong. You've never raised a child. You have no idea what this is like, much less with autism and his heart condition. He's never been a night away from me.
Okay, but I think, is there a point to where you have to understand he has parenting rights to this child just like you do, right?
Yes.
So is there a point to where you'd be willing to agree, okay, yeah, you can take him overnight?
I mean, we would have to see if it would, I don't know. I don't know.
Okay. Judge, let me see if my client has any questions other than that.
All right, thank you, ma'am. You may step down and have a seat at the table. Mr. Murphy, do you say you have something else?
Yes, Mr.
All right, call your witness. Step right up here, please, ma'am.
Could you please state and spell your full name for the record?
Elena Page Reimers, ALAINAREMERS.
Ms. Reimers, do you know Mr. Fenton?
I do.
How do you know him?
He's my mom's boyfriend.
Has he raised you at any point?
Yes.
Can you tell us a bit about that?
He's raised me since I was 12 and provided me with everything that I've needed.
Do you and him have a father-daughter relationship?
I would say so, yes.
What would you say about that experience as him acting like your father?
He's done more than what my actual father could have.
You've never seen him have any kind of drug problems or
No,
any criminal activities?
no.
Okay. All right. You think, based on what you've seen, he'd have any problem raising a 3-year-old child?
No.
Okay. Those will be all my questions, Your Honor.
Do you have any questions for this witness? You have a seat, please. You testified about that, but to your knowledge, has Mr. Fenton ever dealt with an autistic child that's 3 years of age that's nonverbal?
No.
Thank you. You can step down. Any other witnesses, Mr. Murphy? Do you have any other witnesses you wish to call? This is a temporary hearing on a motion to establish some sort of visitation. The order that established Mr. Fenton's paternity of this child was entered by the child support magistrate on May 20th of 2024. And at that time, the order that was entered was entered based on the failure of the plaintiff to appear, which was Mrs. Hewitt. And nonetheless, it was entered that there would be a child, there would be a establishment of paternity, and that he was found to be the father, that the primary residential parent would be the mother, and that the defendant, as the alternate residential parent, would have reasonable visitation privileges. So it has been established, and what is reasonable to one person is not always reasonable to the other, and that's one of the problems with reasonable visitation. The court finds that it is based upon the distance between these parties, that it is reasonable for Mr. Fenton to have visitation at Mrs. Hewitt's or Miss Hewitt's home for a period of noon until 9 o'clock on every Saturday. Well, we'll make it one Saturday, and then alternate week will be Sunday, and that will continue for a period of 90 days. Following that, he will have visitation consisting of all day, and it will no longer be supervised. In other words, I'm going to graduate that to, it'll go from 8 o'clock in the morning until 8 o'clock or 6 o'clock that night. It'll be day long, and he'll be allowed at that point to remove the child. After 90 days of every week having the child, visiting with the child, we'll assume that there is a problem, that there is no problem, and he'd be able to have the child and go that. That's all I'm going to do on a temporary basis. That will be continuing, and he'll have that child 1 week on Saturday, 1 week on Sunday, but he'll see it weekly because I'm trying to establish a bond between him and the child. This is a difficult situation because of the child's special needs. If you want to consult the CASA people to see whether or not they can assist you in that regard, but there's no evidence before me to indicate that there is any problem with Mr. Fenton as a father. And you can expect that barring something, this will gradually increase to become a lot more like a normal visitation situation. But a lot of that depends on whether or not Mr. Fenton is able to handle dealing with this young man, and whether or not the child adjusts to being away from you, and the special needs that he has are a question for the court. So I'm going to order this as a temporary basis, and then subject to review. If the parties can't work out an agreement, Mr. Murphy, you can revisit this motion. And thank you. And Ms. Hewitt, if you consult with the CASA people and they are able to give you some assistance, then, you know, we can, this is a temporary order, which means it doesn't, you know, if the child has an adverse reaction, and again, I'm going to encourage you in order as a part of this, so that both parties will work to encourage the visitation being as smooth and beneficial to the child, and not create an environment where the child is hesitant to go with his father. So it's part of it's going to be your job is to try to make him comfortable with going to see his father. But if there is an issue, then it can always come back before the court, me or one of the other judges. All right, thank you.